I'm happy to have everybody here. I can't see who's here. I kind of shared the screen to go over a topic that's been on a lot of people's minds for the last several months since the FTC proposed a rule last year, since it finalized its rule and published it in April, and since we kind of went down the road to a pretty cataclysmic ending of it as of yesterday. I put together this particular PowerPoint that you're going to see in front of you over the weekend. And so a lot of it's already outdated. And that's the nature of sometimes when you're a lawyer. There are just decisions sometimes that happen overnight and change things. So I'm going to go through a few things without being too boring, but I can start off by suggesting to all of you that the concern about the non-compete rule and whether it will be enforced or not was answered yesterday, and a nationwide injunction was issued. We'll talk a little bit about what it was going to be, though. And I usually kind of start off telling this, and all of us who are the lawyers that are on this all have physicians who come to us all the time. They have non-competes that exist in agreements that they have. It may be employment agreements or other relationships. And I can't tell you how often I always hear from people, oh, they're not enforceable. They can't tell me to work. Well, they've been enforceable in Florida and restraints on trade for a very, very long time. We codified more specifically the land of non-competes back in 1996 to deal with it. And there are, 33 plus states that have in some form or fashion non-competes that exist out there. There are 4 states that don't have them: California, Minnesota, North Dakota, and Oklahoma. And last year, Colorado, basically late 2022 or so, now a couple years ago, they almost eliminated them totally. So their law is very different, but everybody has little powers. Some states that you see here don't even have them. And it makes it interesting because there's a lack of uniformity, but it is arguably a state power that exists within states under the 10th Amendment for their police powers about how things happen within the state. And the states have promulgated these different statutes, and they are in fact enforceable. Even though we hear it a lot, they are enforceable. They're used a lot. And in employment agreements I write for most people, depending on whether I'm looking at them for a provider, I warn them about what they are, what they mean, and their enforceability. And if it's for a practice has a discussion about whether they want them, how they want to use them, and how enforceable they are. I will tell you, for the rule, some of the stuff, again, is going to be a little outdated, but the rule that was put out there that was going to become effective on September 4th in a couple of weeks basically eliminated all existing non-competes that were out there. And under the rules, you'll see that in their discussion, it's about 30 million people that were affected by the rule that was put out by the FTC. They basically said the non-competes that exist for what they defined as workers were going to be no longer enforceable, except for certain agreements that were with what we call senior executives, which I'll talk about in a minute, which is a very small subset group of people. And it basically informed everyone, you have to notify your employees that their non-competes are no longer enforceable. You had to do that in writing. You had to do it at their address, send them a letter. There was a model letter that was associated with it, and you couldn't go anywhere or try to enforce them. There is guidance that I put in here that was put out by the FTC. It was very good. It was a 4-page document. It talked about what happened. But understand, when they wrote this rule was written by a 5-person board. They are made up of 3 Democrats and 2 Republicans. It was a 3-2 decision when the rule was actually put out. And they had over 26,000 comments putting together this rule, thinking their way through it, figuring out what it was. So specifically, its applicability was for all workers, but it was not for existing non-competes with senior executives, non-competes in conjunction with sales. And you see that a lot these days when hospitals come in and buy practices, or there's private equity transactions or other transactions that exist where there's a substantial amount of money that's used for the purchase of assets or stock that relate to a healthcare entity. There is generally non-competes, and those are always in there because no one spends $20 million to have the people that they just bought the assets for go across the street and sabotage the business they just purchased. So that was an exception that was here. They had an exception for franchisee and franchisor non-competes, as well as those imposed by nonprofits. So in essence, the purpose of the rule was to invalidate non-competes and prohibit future ones, even against senior executives. And so who was that for? That was for people that were full-time. That was for people that were part-time. people designated as employees, independent contractors, interns, externs, volunteers, apprentices, and others, except as indicated, senior executives. And senior executives were people who made over $151,164 a year in compensation. I don't know where they pulled that number from. It's a pretty specific number, but that was the number. But they also had to be in a policy-making decision. There are plenty of physicians that make in excess of that money, but they are certainly not in policy-making positions. And they define that in the rule and in their discussions as people that were presidents, CEOs, or the equivalent, or any officer of a business entity who has policy-making authority for the business entity, similar to an officer. Policy-making authority was limited to, and this is important, having final authority to make policy decisions and control significant aspects of a business entity. So you can have lots of people that are owners in a medical practice, for example. They all own 2 or 3%, but none of them individually has final authority. None of them individually controlled significant aspects of the business. They could all make $1 million a year, and they would be not be considered senior executives as I read the language of the rule. So as it related to senior executives, however, going forward, you were not allowed to enter into them after September 4th. They were going to enforce the ones that were in place as of September 4th, but after that, no new ones. So these were the steps that people were to go through. These were the discussions I was having with people last Friday, because as of last Friday, everything was still kind of in limbo, and it looked like the rule was going to go into effect. So when you looked at the compliance, it did not include non-competes with future employments. You couldn't use any paperwork. You couldn't use employee handbooks. You couldn't use workplace policies or websites to kind of create de facto non-competes. It wouldn't just be in an employment agreement. And step 2 was you had to affirmatively give notice to anyone that had a non-compete, even if they didn't work for you any longer. And there was a specific notice that was supposed to given out, and you could be penalized by the FTC for not having done that. So real quickly, and I'm kind of getting a little redundant because the rule is gone. They provided a sample letter to the companies. It was a very interesting sample letter that went out. It was very short, but it said, we're not going to enforce the non-compete. You can't have it. You're welcome to do whatever you want to do and work wherever you want to work. And that had to be sent out by September 4th. So as I say at the bottom, I'll talk a little bit about things. Everyone was waiting for what was called the Ryan Court decision. And I'm going to bypass the notice because it's really no longer relevant. There were 3 cases that were out there. The first one was the Ryan Court. I'm going to talk about that one last. The second case, so the Ryan Court was in the Northern District of Texas out of Dallas. That was the first case that went. There was another case that went in Pennsylvania. What was interesting about this ATS tree service case is there was a complaint filed and a movement to get an injunction, and the plaintiff sought a preliminary injunction. That federal judge, who was appointed by the Biden administration, contrary to the Ryan Court, which we'll discuss, found that the rule was valid, found that the FTC had the authority to issue that rule, and Judge Hodgson that stated that they had the authority for procedural and substantive rules as are necessary to prevent unfair methods of competition. Therefore, that court, while stating that it thought they had the authority to do the rule that they did, refused to issue a preliminary injunction. And so no injunction was done. The rule was going to go in effect in the state of Pennsylvania. That's just the way it worked. There was no anticipation, and I'm not aware that anything further happened with that particular court decision. There was a lawsuit that was filed here in Florida very recently by the Villages. Those of you who all know what the Villages is, the big retirement community that has a lot of people, and it really dealt more with real estate than anything else. And this was filed with the Middle District of Florida. It was filed in Orlando. Oral arguments were heard in Jacksonville because all of the people that were interveners that joined the suit. And a couple of years ago, the federal court had actually heard a couple of cases as it relates to the non-compete that was existent in the agreements that were used by the Villages. That court specifically held, the Middle District specifically held that they were valid and that they were appropriate. So that was one of the arguments that was made to the court now that said 2 years ago, this court said these were valid. We want you to uphold these now and enter an injunction so that we won't be subject to the rule that's supposed to go into place banning non-competes on September 4th. That judge had a hearing on the 14th and issued an preliminary injunction on the 15th, which is kind of unheard of. And what the judge in essence did was, which is unusual for me, perhaps maybe not for my other two colleagues that are on here, the judge basically took a copy of the transcript where all the lawyers and the judge discussed everything and attached it to an order and said, that's my reasoning. That's why I don't think this can be done. And so the judge did, in fact, issue a temporary injunction to stop this, knowing everyone knew the rule was going to go into effect on September 4th. Notice when he entered an injunction, that injunction was exclusively for the properties of the villages. It was not nationwide. It was not Florida-wide. It was only for the people that were subject to that particular action. So it didn't have any long-term force and effect, but it did shadow that there were going to be some issues. And what was interesting is I have 3 decisions up, and I'm about to talk about Ryan, and all 3 of these federal judges came to their conclusions in different ways. None of them are really consistent. There's a little bit of a change. There's one way on the right, there's one way on the left, and there's one a little bit in the middle. Judge Corrigan from the Middle District of Florida was a little bit in the middle. He believed that the FTC did in fact have authority to write some rules and deal with the issues before it. He just thought it was too broad in which the way they did it. Remember, the Pennsylvania judge said they have all the substantive authority they need. They can write whatever they need for unfair competition limitations, regulations, and what have you. So this one said, I believe a little bit of that, but it's not carte blanche. So now, and he had an interesting quote, and I'll read it just for the purposes of this and those who are listening later. He cited from Justice Barrett's concurring opinion in a recent case. It says, if a parent gives a babysitter a credit card and says, make sure the kids have fun while we're out, the parents might expect the babysitter would take the kids out for ice cream, but would not expect the babysitter to take the kids on an overnight trip to Las Vegas. His point being, you can do a little, but you can't do all the stuff that's being done and having the breadth of what they had. So now I'll go to Ryan. And in the order of things, Ryan was actually the first case. And Ryan was the case that happened where another judge, this judge appointed by the Trump administration, did give a preliminary injunction. And that was a case that was done by Ryan LLC, which was a tax entity that prepared tax and provided tax services. There were a number of interveners that jumped on this, including the U.S. Chamber of Commerce and some others. And they made their presentations to the judge, and the judge granted the preliminary injunction to make the rule unenforceable as to the parties, Ryan and those that intervened. So now we were still in this position at the time where those of us that were watching it said, this is the first case that came out. It came out July 3rd, and we have a judge that says this shouldn't be enforced, but she didn't issue an order that was blanket across the country. She just issued an order for the people that had done it. So for everyone else, it was going to still stay in place. Then along came the Pennsylvania decision. That judge chose not to issue an injunction. And then after that was the properties decision just last week that issued a temporary injunction only for the people that were there. So as of Monday, when I finished preparing and putting this together and just banging it out real quickly, it looked as if on September 4th, there was going to be a rule that went into effect that affected everyone in the nation, except for those parties that were involved in these lawsuits where the 2 injunctions were issued because the judges had given them those. Without getting into large deal for discussion.
Sorry, everybody. Technical difficulties. Oh, there's Greg again. I'm going to admit him and hopefully he can pick up right where he left off.
This is Charmaine Chu from Smith, Halsey, and Busey, and maybe I can get us started while we wait for Greg. We heard Greg talk a little bit about giving these notices, and Ben, maybe you can weigh in a little bit as well. Notices to employees that may have had non-competes that they were going to be now invalidated. Ben, what are you advising your clients? I've certainly had a lot of physicians and employers both come to me saying, well, as of the state, non-competes are not going to be valid at all. Would you recommend a reminder to physician employees now so that they don't feel that, if they've missed the news about this decision, so that they don't feel that they're off the hook on their non-competes? What are you doing for your clients?
And so well, it depends, I guess, in terms of physicians or individual physicians that come to me and they ask me whether this rule will let them off the hook. I pretty much tell them no, it's not, because there's a big hurdle to go through, which is exactly what I think Greg was explaining. So although it was a good try on part of the FTC, I actually did not foresee it going very far because the industry would challenge it. Especially like when you look at like all of the software, the intellectual property contracts that are out there, the engineers that are involved in that sort of stuff. This FTC rule didn't just affect the physician industry or the healthcare industry, but it also impacted all of these other industries that have a significant amount of intellectual property in it. So I just didn't see it happening, and I've been telling people that, and I expected my employers to start preparing for it. But really, they didn't need to do a whole lot because what they needed to do was qualify a physician for my employer clients, meaning the larger corporations. I was telling them to basically start incorporating the strategic component of like employment into their employment agreements, and that they were getting ready to do, but it looks like we didn't have to do it. Charmaine, I'd love to get your thoughts on it as to how you approach employers versus physicians and how you differentiated on what you advise them.
Yeah, certainly from the employer perspective, sort of issuing a notice now saying, haha, that all the non-competes that you may be subject to are still in place. So too bad. That's sort of to me, it's a PR nightmare, regardless of what you think of the legalities of the decision, right? Right or wrong. But I think it people stand to be reminded both on the employee and the employer side that, these non-competes for the states that permit them are now still standing. So, don't think that come top of September, you're going to be fine in leaving an employer and then not honoring your non-compete. That certainly can still get you into hot water. And I see that Greg is back. So my suggestion was to be, maybe a light mention, employee newsletter or something like that, even a social media type of mention, so that it's not a PR individual decision or issue, but there is some recognition of it. Hey, Greg, good to see you.
Hey, my apologies. The internet just died. So I'm back, and I guess there was a question. So I apologize for that happening for everybody, and however disruptive that may have been, but it did get back up and I was able to get back in. And I was wrapping up the end anyway, basically to talk about the Ryan decision, which I think both Ben and Charmaine were addressing, that in essence, late yesterday afternoon, the judge in that case did in fact issue a decision saying that she believed they had no statutory authority to issue the rule, and the rule that they put out was arbitrary and capricious. And based on that, in the federal APA, that required her to set aside the rule and employ it nationally. And I always thought, given her initial conversations, if she found they didn't have the authority to issue the rule and it exceeded their authority, it would exceed the authority for not just the people that were the plaintiffs, but if they didn't have the authority to issue it, it would exceed it for everyone in the country. And so that was kind of expected when the decision came out. It's a well-reasoned decision. There may be some disputes about what that is. I think for all of us, I certainly had a number of clients that were employers who we told them that we were aware. Originally, the judge said she would issue her decision by August 30th. So my last slide, which I won't put up, there was only one more slide, basically said, stay tuned, a lot's going to happen in the next 10 days. And the decision came out last evening. And so it doesn't reconcile with the other courts. There's certainly the possibility that the FTC can appeal that decision. That will be appealed to the Fifth Circuit Court of Appeals in New Orleans. It is a more, as described by people, a more conservative bench than it is others. But even if it's appealed, and this goes through the process, we've all watched the length and time with which cases go through different circuits and make their way ultimately to the Supreme Court. It could be years before this happened. So I'm not surprised that they issued it. As far as the employer side, I had people ready, names listed and everything else so that they could act quickly over what would be Labor Day weekend to ensure that they would submit the appropriate notice in the form that was given by the FTC to those people that were subject to the non-competes. A lot of people are aware of it. On the employee side, I had lots of people call me and ask me, well, that's going to go into effect, right? They're banned. They're not allowed to enforce it anymore. To which I said, the rule goes in effect in September unless it doesn't, unless there is an injunction that is issued that forbids it or basically sets aside the rule, which is in essence what happened. So I do have a large number of clients that are going to be very disappointed that the ban was basically tossed aside. A number of employers are going to be very happy about it as it relates to that. And we'll just have to see. As far as the notice now that the ban doesn't go out, that's a decision amongst practices. I wouldn't send off a letter to everyone, I think as Charmaine said, and do the ha, don't think you're out, you're free. We're still going to enforce these. They're still in written contracts. They're still enforceable contracts. They have still been signed by the parties to whom they can be enforced against. You don't need to rub it in anybody's face. There can be kind of a decision. And I'm sure if you do a simple search, Google search or somewhere else on the FTC ban, you will find pages of articles that were written between last night and noon today, the injunction that was issued. And it should be something that those employees who were particularly paying attention to this can find very easily. So just some quick thoughts. I don't want to run over time because my internet decided to mess up the recording and the presentation. But if there's any other further questions, I'm happy to answer it or.
I just want to say it's unfortunate for the physicians that are employed that this happened. You know what's kind of funny, Greg, is that us as attorneys, we can't sign non-competes. We don't sign non-competes. We are free to go basically anywhere we want, and our clients are welcome to follow us. That's what the Florida Bar rules say. And the Florida Bar has really kind of stood up for the attorneys to be able to maintain their independence and maintain that attorney-client privilege. Yeah, I wish there was a way to see the FMA kind of take a role in that and kind of push the ethical issues behind a physician-patient relationship. And
I think it's ironic, and the irony of it is the premise behind that decision, right? And the premise behind the model rules that governs me, you, and Charmaine, and other lawyers as it relates to non-competes is to allow clients to have the opportunity to choose the lawyers who they want. And the irony of that is that all people should be able to choose the healthcare providers for whom they want to see. And because Dr. Jones and Dr. Smith don't get along anymore, that shouldn't impact whether you see Dr. Jones or Dr. Smith. That's kind of ironic, and those decisions come out from both courts, and you see that. There are some other interesting things as it relates to attorneys and other providers, but I don't think, and I don't mean this in a pejorative sense. I don't think our relationship with the clients is more sacrosanct than a relationship between a physician and a patient. But that is where the law is, and for those on this phone call, what's interesting is, historically, if you look back and find out where non-competes really got their genesis in, it comes out of the medical field in the late 1800s through the common law process of people protecting who their patients were and people who they saw. And then it kind of developed and moved its way through the years. But those were, that's kind of how it started and ultimately made itself to where we are today. I think that one can certainly argue that it's unfortunate. There are certainly things that need to be protected. The rule itself didn't stop non-solicitation provisions. There were certain things that could be done that would protect things about maybe soliciting patients and other kinds of things, but it would allow people to compete. And there's been some differing opinions over the last few years out of the courts in Florida about what in fact are, patients and prospective patients and how that works. But there's been some clawback the last few years. The courts have really dug in, I think, and enforced non-competes more than they had maybe 8 to 10 years ago. So we still have a plethora of case law. We still have enforceability here. There are still points, like you say, Ben, about whether it should or shouldn't be enforceable. And I think the arguments for why they are not enforceable for attorneys are equally applicable, if not more, at least to the physician-patient relationship or a provider-patient relationship.
Yeah. It's funny among attorneys. there's this rule about non-attorneys can't own a law firm, right?
Mhm.
And then there's a whole corporate practice of medicine. Any thoughts on that, Greg? As to
What about
how,
the corporate practice of medicine? I take the position we don't have it in Florida. And the reason why I take that is for a couple of reasons. I mean, there are a number of states that do. California is an example that doesn't have non-competes and has a corporate practice against medicine. The reason why I take that position is we have some practice acts that don't allow people. Optometrists can only own optometrist practice. Dentists can only own dental practices. Chiropractors can only own chiropractors. You can't have outside owners. They can be of a multidisciplinary practice, but they are the only ones that have restriction is in each one of their practice acts. And as lawyers, we always kind of take the position that if they wanted to include it in the allopathic or osteopathic medical practice acts, like they did in chiropractic and dentistry and optometry, they would have done it. And they chose not to do it, number one. Number two, the insurance industry, as you know, pushed very, very hard to create the Healthcare Clinic Act, which was a concept that allowed non-owners to go out there and register, pay $2,000 a year, with an application, get vetted so that they could own and be engaged in the ownership. So the concept of the corporate practice of medicine is to not have dollars influence the decision-making process about healthcare. It's the same reason why we have the Stark Self-Referral Law and the Self-Referral Act that exist in Florida, is to try to take out that, whether it's a subconscious or conscious decision that's made to influence how care is made, the decisions that are made. But we don't have that in Florida. We've, in my opinion, done away with it, particularly after they put all the legislation in about the Healthcare Clinic Act. I don't know if you Shane, have any other thoughts, but that's kind of.
Yeah, no, I just find it really odd, like what you just said about the whole chiropractors and non-chiropractors. They can't be partners, chiropractors have to be partners with other chiropractors, just like attorneys with other attorneys. It's too bad that physicians and dentists too, by the way, dentists also
sure.
can only be partners with other dentists, not non-dentists. And I find it, ironic that that so much of like the corporate side got into the healthcare space that it took away that sort of a protection that I think patients really need ultimately.
Well, I mean, look, that's been a recurring issue. I've watched for years in front of the Board of Medicine when managed care would go in front of the board when they wanted to do certain rules and say, you don't run medicine, we do. This is what we do. And we tell people what they're going to do. And the board says, I don't care at the end of the day if you guys decide whether it's a covered service and you'll reimburse it or not. If we believe the standard of care is X, whether you pay for it or not, and a physician fails to do it, we will still discipline the physician. So that's kind of that corporate approach that says we run it, and if we pay for it, we say it's okay, versus the regulatory board still saying we have oversight and we still believe the standard of care, notwithstanding any particular corporate influence that might be there, will still discipline and do things.